For spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed his grace on thee, and crown thy good with brotherhood.
Well, good morning, everyone. It is the top of the hour. A copy of the Open Meetings Act is located on the north wall of the legislative chambers, and an automatic external defibrillator is available on the back wall of the legislative chambers. Please stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
We'll begin with the agenda for the Douglas County Board of Equalization. Roll call, please.
Commissioner Boyle, Commissioner Duda, Commissioner Kraft, Commissioner Morgan, Commissioner Rogers, Commissioner Tusha.
Here.
Madam Chair.
Here. Item A, approval of the minutes of the Board of Equalization meeting held Tuesday, September 23rd, 2014. And item B, call for a meeting and set Tuesday, October 7th, 2014 as a date for hearing on certified assessment corrections reflecting the addition of omitted property to the tax rolls or increased value on property.
So, move for approval.
Second.
Any questions or comments? Please vote.
Motion passes.
Citizen comments. Is there anyone here in the chamber wishing to speak to the Board of Equalization about an item not on the agenda? Seeing none, we have one resolution, applications for exemption on motor vehicle recommended for approval by the county treasurer, and we have one appeal that has been asked to be removed. And so I would ask for a motion for resolution D and adjourn.
So moved.
Second.
Any questions or comments? Please vote.
Motion passes.
We'll go to the agenda for the Douglas County Board of Commissioners. Roll call, please.
Commissioner Boyle, Commissioner Duda, Commissioner Kraft, Commissioner Morgan, Commissioner Rogers, Commissioner Tusha.
Here.
Madam Chair.
Here. Item A, approval of the minutes of the Board of Commissioners meeting held Tuesday, September 23rd and Thursday, September 25th, 2014. Item B, approval of claims submitted for payment processed through Tuesday, September 30th, 2014.
Motion approved, A and B.
Second.
Any questions or comments? Please vote.
Motion passes.
Consent agenda, items A through L for a total of 12 items.
Motion approved.
Any questions or comments on the consent? Please vote.
Motion passes.
Citizen comments. Is there anyone in the chamber wishing to speak to the board about an issue not on the agenda? Good morning.
Good morning, Commissioners.
Morning.
My name is Melanie Williams-Smotherman, Director of the Family Advocacy Movement. I'm actually here with a parent who wants to speak, and she's been meaning to come here herself so that I'm not the person speaking on her behalf. And she is currently getting her handouts stapled, I think, in your offices so that she can bring them to you. So I'm going to just use a couple of minutes while she's doing that to say that in the case that I have brought to this board, there's been a lot of activity over the last, I don't know, month since I've been here, and almost all of it has had to do with attempting to silence my voice and the voices of others, and I'm very concerned about that. And I continually bring this to your attention because I don't think that's what we as taxpayers and as citizens would expect to be paying for. You know, when we're talking about the protection of children, we should be talking about the protection of children, not paying professionals, attorneys, to misuse the law, to attempt to intimidate, harass, and silence. And that's what's happening, and I'm concerned about that. Now, one of the days after I spoke about this case, several attorneys, or a couple at least, came to this podium and I think issued some veiled threats to this board for being concerned about the reports that citizens are bringing to you. I think that's outrageous, and it's something that all of us are concerned about. I don't think it's a proper way for attorneys to behave. I'm not an attorney. I'm not paid by the state. I'm not paid by the county. I'm a citizen who happens to give my time as an advocate because I care and I have experienced these sorts of things myself. So that's how I have chosen to use my time. When I come up here to speak on behalf of families, I'm speaking also on behalf of myself as a citizen. And the harassment, the intimidation, the use of law in that regard is not appropriate. I guess that's primarily the comments that I want to make. I think that, well, the other day I went on a radio program with this parent and the Scott Voorhees show, and a lot of people who have a vested interest in maintaining this sort of activity, this inappropriate activity, would suggest that we shouldn't be speaking, that we are simply, attempting to gain attention for ourselves because, as Mr. Kraft said, he called me narcissistic. Again, I think it's incredibly unprofessional and troubling that citizens and advocates should feel stifled about coming forward and using 3 minutes to speak on a topic that is very important. And I think it's recognized as important not just by myself, but by our legislature and everyone. That's the dialogue in our state right now. So the notion that, the very few citizens who feel confident enough to come up here and speak on rare occasion should feel guilty about that is something that we should all take personally.
Thank you, Melanie. Just Commissioner Boyle.
Melanie, excuse me, I want to say for myself, and I think the other commissioners, we weren't intimidated by those lawyers. And if I could, as a lawyer, I'll tell you what I think they were doing. I'm certain what they were doing. First of all three have practiced actively in juvenile court for many years, and I know all of them, a couple of them, one of them particularly very well. And what they were doing was exercising their First Amendment right to defend or to help explain what the juvenile court judges were doing. The judges can't speak. It's not permitted. They're not allowed to defend themselves publicly. So I wasn't offended by it. I certainly don't want you to feel like I, for one, am not trying to stifle any conversation here. I think this is a wonderful public forum. I think I don't want you to feel guilty about anything. You're doing what you feel you should do, and that's what First Amendment rights are all about.
May I say that because we do have the First Amendment right, I think that what most people don't expect is to see the threat of subpoenas of our personal phone records. That was coming from one of these attorneys for whom you're speaking, and I am very careful about the caring approach that I have and that I take with regard to families, and obviously my intent, I would say the result of what I say does not embarrass children or harm families.
Right.
What I say is I bring issues to the public's attention that I would argue would protect children and families from systems that are very rarely overseen by independent eyes and held accountable. And to be met with threats of subpoena of my personal and private communications as a private citizen, I'm not an elected official, I don't believe is appropriate. And I think that these are tactics that would represent a misuse of law.
Well, if I could comment about that, there has to be some reason before there has to be some reason for someone to subpoena someone else's records, and they can't just do it, walk in and get a subpoena. So I wouldn't be, if that, I guess I do remember something like that, but I didn't take it as any kind of a threat to anyone, because you can't just do that. I mean,
So
it
you're
has to
saying
be
a judge
said.
would not actually sign off on that, but yet
No.
they're sitting in a file as a reminder of the threat that it could happen at any time?
It really can't.
Okay,
Because
well,
there has
I'm
to
glad
be-
you as an attorney can feel confident about that. Me as a citizen with, you know, I'm threatened by it.
Yeah. Well, that's not right, but there has to be some kind of an action file before a subpoena could be issued. You can't just drop one out of the sky. So it's unfortunate, and it's not good that you feel threatened by that. I
And we as
apologize for
taxpayers
that.
have paid for it as well, because that's time that this particular attorney spent making up a subpoena for you, for Commissioner Borgeson, for the parent for whom I advocate, for me, and for a colleague in this advocacy work. And so this attorney has spent an awful lot of time finding ways to use the law to intimidate and harass us. And I think he's billing the county for it, which means we're paying for it.
I don't, is he billing us?
They're on
Yes.
file. I mean, they
I mean,
haven't,
but is somebody billing us
Yes.
oh, yeah, they're.
for that?
I don't know, we haven't.
Well, we'll
seen
look into
detailed
it.
billing.
We do have we have,
Oh.
somehow, I think maybe by accident, we've gotten a hold of a couple of itemized bills, because we don't usually get to see itemized bills for what these people are doing, and instead we just, I guess, have to pay. But I think that it's important for us to start demanding a breakdown of what these attorneys are doing, especially given this evidence.
Thank you.
Thank you, Melanie.
Would you call? My computer's down.
Hello there.
Hi. You go right. Thank you.
Okay, go ahead.
And I'm just
And
going to say, I'm a little
I
nervous.
know you
This
are.
is my
It's your
first time here.
So just take your
Um,
time.
So I
Just
wrote
state
every-
your name and
Oh,
address for me.
I'm sorry. My name is Lori Flynn. I live at 1514 North 104th Plaza, Omaha, Nebraska.
And can you speak into
Oh.
the microphone? There you go.
Okay, sorry. Do you want me to re-say it?
Nope. you're
Okay.
fine.
And I just wrote everything down, but, and I actually wrote it towards also speaking with Mr. Kraft, as he is my elected official. I am here to talk about the Douglas County Juvenile and Family Courts. I have heard many of you say that you are unable to find out what is going on up on the 6th floor, and so I am here to shed some light on the subject. I am very concerned about many comments Mr. Kraft has made regarding legitimate concerns that I and other families have about the way child welfare and other systems are run in our county. Both Laura McCormick and Melanie Williams-Smotherman have come before the board at my request and at my behalf, and now I feel the time has come to report my concerns directly to you. To inform you in person how my constitutional rights have been trampled at almost every turn in this mismanaged and highly questionable case. Of primary concern to me are the actions of many people who hold the title of guardian ad litem, both in my case and also those who have nothing to do with me or my family. I've given you 2 emails. Those would be the top 2 pages. 2 emails that are written by Maureen Monahan. She is not in any way involved in my case. She is not providing guardian ad litems through her contract. Nothing. She is not involved with my case. And yet she is sending documents and information about me and my children to Patrick Bloomingdale, Tom Incontro, and Mark Kraft. And I personally find that a little bit suspect when then 2 weeks later, Mark Kraft votes on her contract. Voted on her contract.
Oh, I couldn't hear
Oh,
you.
I'm sorry. I had surgery over the weekend
It's-
on my heart.
No, it's me, believe me.
Oh.
Ask my wife. You're not listening.
And then, you know, it's my thing is what kind of political game playing is going on with that. I have also given you bills from Jeff Wagner and Peg Stevens. Jeff Wagner is my children's guardian ad litem, and Peg Stevens was assigned as guardian ad litem for me until it was successfully argued, once Judge Sirkovich was off the case, that I did not require a guardian ad litem, nor did I need one. If you look at Jeff Wagner's bill, he is charging my case for emails from the court regarding Laura McCormick, and also about researching closing the courtroom to the public and restraining gag orders, all designed to hide what is really happening up there from the public. The courtroom was not closed, and the gag order has been removed because they are not only going against our state laws, they are against the Constitution, and you have the final rulings. It's the shortest one that's in there that says order, and it just says there's no gag order. The people I have given permission to talk about what is happening to my family have been harassed and intimidated for doing so. I have handed you a notice of intent to serve. It's the thick one. Those are the subpoenas for Melanie Williams-Smotherman, Laura McCormick, Commissioner Borgeson, and Commissioner Boyle. And I would like it to be known, I have never spoken to Commissioner Boyle prior to getting that, not once, not in emails, anyway. Did not know him. I mean, I would know you if I saw you, but I've never spoken to you. So, anyway, Jeff Wagner not only prepared, he billed the county for doing so, and his itemized bill. I don't know how they were maybe mistakenly put in my file, but I've given you the itemized bill that he billed the county for preparing that. I've been told he does not intend to follow through with them, but he was already paid for them. I believe they are meant to intimidate people from looking into my case. It's my understanding that goes against the Code of Professional Conduct for lawyers, using the law to threaten and intimidate. Something isn't right in Douglas County, and it's time to fully investigate what that is. And I really wish that Commissioner Kraft was here right now, because and maybe he can watch this later, but I wanted to say I'm so offended that he has sat there and yelled about me and said things about me when he has no idea what they're doing to families up there. He has no idea what they've done to me. And I voted for him to sit in that chair, and that's the last vote that he'll ever get from me, because I'll never give him another one. This can happen to any parent in Douglas County. Made up cases, questionable rulings, legal maneuverings to cover up things that should never happen to any family. I could sit down with any of you and go on for hours about what has been done to my family, and I have the documentation to prove everything. And everything that Melanie Williams-Smotherman has ever told you about my case, because I've watched, has been the 100% truth. She's not embellished. In fact, she's played down quite a few things. We are not fodder for lawyers to exploit and profit from anymore. One more thing to tell you, and I think this is very important. I am not able to get the transcripts in my own case. I don't have them, and this is on me. It's my case, and I cannot get the transcripts. I've given you 2 orders. One states I can have them, and then the very next one, Judge Sirkovich says, well, she can't have them. I'm disabled. She wants me to run down to my attorney's office and read them. I'm obviously a party to the case. My children want to come home, and they've told the guardian ad litem this, and I'm sorry I went over.
Thank you, Laura. Are there any questions or comments on this? I think, again, there's some people who don't believe that this is the proper forum, but I believe that as elected officials, we have the need to hear about these things, especially now that I think we have the attention of the legislature to try to make some changes to the system. And it not only affects monetarily what taxpayers are paying, but it affects the children and families to which we're supposed to be serving. And
absolutely.
So I appreciate your courage to be able to come before the board and give us the details of your case. And I'm sure we will all take this and read through it.
Okay.
Thank you.
Okay.
And I hope you feel better.
Thank you. Thank you. Thank you.
Anyone else wishing to speak before the board about an item not on the agenda? Hi, Laura.
Hang on a second before the clock starts ticking.
as you're getting ready, I think what the other thing that this reminds me of is when we had the issues with the truancy stuff, and people were trying to bring information, and it was all kind of I can't believe that would happen here, that would be going on here. People were in denial, disbelief. But it was the parents who finally came, if you remember, before the board, and again, being very courageous to come before the board, telling their stories about what the problems were. And we're supposed to be here to try to make changes to policies that are not very good policies or very good laws. And so again, I hope you all will read the information, and then I'm sure we'll have further discussion as this potentially moves through the legislative process this next year.
Will this automatically come on, or does it? How does that work? I don't know. I don't use it all the time.
There you go.
Yeah.
Yep.
Okay.
Okay,
So,
get it. Turn it.
you all know me. My
Laura,
name's
turn
yeah.
it.
Oh, the other way.
There you go.
There.
Yep.
Can you see it? Okay, my name's Laura McCormick. I live at 7414 Valley Street, and I spoke with Commissioner Borgson and told her I do believe my comments exceed 3 minutes, but I in no way want to be disrespectful. So if you'd like me to stop speaking, that will be fine. I'll come back next week and finish whatever remains for my comments. The choice is yours.
Why don't we give her...
Let me... Oh, sorry. Let me begin by stating my comments are directly related to the governance of Douglas County. I'm going to quote from a memo that Maureen Monahan wrote directly to Mark Kraft. In short, all Douglas County can do is pay. Douglas County can pay $65 an hour for cases that average between 25 and 30 hours a year, or continue the contract, which provides substantial savings for Douglas County taxpayers. Maureen K. Monahan to Mark Kraft, June 16, 2014. Unfortunately, Maureen forgot to mention that Douglas County taxpayers are receiving services that do not comply with state statute or with the Nebraska Attorney's Code of Professional Responsibilities. Let's begin by considering a portion of Judge Susan Baz's comments about the environment at the Douglas County Courthouse, and this is page 129 of the transcript from Judge Schatz's disciplinary hearing. Judge Schatz faced disciplinary action because he let a 5-time felony DUI drunk attorney out of jail early after the drunk lawyer's girlfriend made a tearful midnight phone call to the judge. Ms. Winner, attorney for the state, asked Judge Bazis, question, are you familiar with the culture in Douglas County, the Douglas County Courthouse, well enough you can describe sort of how things get around? Judge Bazis, answer, yes. Question, can you just generally describe that culture? Judge Bazis, answer, well, the best way I can probably describe it is it's like high school rumors. People like to talk. If something is going on, people are usually talking about it. Question, and the some things going on include the conduct of judges and the conduct of staff. Judge Bazis, answer, yes. Question, in your experience, does that kind of information become widely known and widely discussed around the courthouse? Judge Bazis, answer, yes. And she has lots more credibility than I do because she's a judge. Why is Judge Baz's testimony relevant? Because the judge describes the way in which those in Douglas County with power and authority behave when making decisions about the lives of everyday citizens who enter the courthouse seeking justice. Decisions on child custody disputes, termination of parental rights, or multi-million-dollar contracts awarded to prominent attorneys in our community can be made in response to gossip, innuendo, and political favor. Please consider the attached documents in your packet. On June 28th, 2011, I appeared before this board. The meeting began at 9:08. My comments became part of the official record and consisted of a 7-page document. The official public record is stamped and has been notated by the Comptroller's Office. This document includes 2 pages of text, which I read into the record, and 5 pages of numerical analysis. The first sentence of my written comment states, my name is Laura McCormick, and I am a lifelong resident of Douglas County. To the best of my recollection, Ms. Kristen Lynch, Deputy Douglas County Attorney, was not in attendance. It seems ironic now that these comments made more than 3 years ago have even greater relevance given the scathing audit report produced by Foley regarding GAL in this county. The next document in your packet is an electronic mail exchanged between 3 attorneys, Mr. Adam Astley, Ms. Kelly Westland, and Ms. Margaret Mark. These individuals represented my ex-husband and our 3 children in the very contentious district court divorce proceeding, Holmes v. Holmes. Mr. Astley makes some very condescending comments about me in his email, which you can all read. His comments appear to be an effort to discredit me and undermine my understanding of the GAL problem. But the most interesting thing about the document is the second page. Mr. Astley received a fax from the Douglas County Attorney's Office, which he forwarded to my children's attorneys, along with his criticisms of my intellect and ability to understand the GAL situation. The fax from the county attorney was purportedly a copy of my comments before this board on June 28, 2011. Which brings me to the third document. I call it Miss Lynch's creation. This is the fax that Ms. Kristen Lynch sent to Mr. Astley. Please note that the document she sent Mr. Astley using the county attorney fax machine is not public record. The document was sent on, Wednesday, June 29, 2011 at 3:04 from a county fax machine with the number 402-444-6817. Please note the document, including cover sheet, is 3 pages long and begins with the words, "My name is Laura McCormick," and handwritten above McCormick is the word Holmes. I did not write the word Holmes. I believe Ms. Lynch did. Please note that this document is missing the comptroller's notations. The 5 pages of numerical analysis are missing. This is not the official public record. Please note that Ms. Lynch at one time worked at the comptroller's office. She understands the record, how it is kept, and as a licensed attorney, she should understand it is a violation of the law to alter a public record. Please see the 4th document in your packet. That would be Ms. Lynch's response to me. This email was written on March 5th, 2014 by Ms. Kristen Lynch to me and an assortment of others. The email states that Ms. Lynch's job title and that she was assigned to advise the Douglas County Board of Commissioners during the meeting of the board on or about June 29, 2011. Ms. Lynch further states that Mr. Astley requested a copy of the document I presented to the board and that she, Ms. Lynch, acted in accordance with Nebraska 84712. Does public record law endorse providing something other than the public record to the requestor? Why would Ms. Lynch alter my comments? Why would Ms. Lynch be corresponding with my ex-husband's prominent divorce attorney? Is it a crime to exercise your First Amendment rights? Why would Ms. Lynch respond to a request for a document when she is not the custodian of the document? Please note that the public records requests are to be in writing and are directed to the custodian of the record. As a regular requester of public records, I can report it often takes weeks for lowly citizens like myself to obtain documents from Ms. Urich. The comptroller's office is much more responsive. Mr. Astley, though, received his altered document in less than 24 hours. I also, for your convenience, have attached in your packet a copy of Nebraska Public Records Law 84712, and boy, do we ever need to beef up aspects of this. Please see the 5th document in your packet. This document is a letter from Ms. Christine Kostantakos. This letter is addressed to the members of the GAL bid committee, which was responsible for evaluating bids used to select the county guardian ad litem providers. Ms. Kristen Lynch was a member of this committee. Back in 2003, there was extensive discussion before this board. I know because I've listened to all of the recordings about Ms. Lynch and her very significant role in selecting the vendors chosen for the multi-million-dollar Douglas County child lawyering contract. Ms. Monahan's firm was selected as a vendor, and the Monahan firm has been the target of criticism due to allegations that attorneys do not meet with their child clients, prepare reports, or produce coherent billings. At the time I made my comments about GAL in 2011, I had no idea Ms. Monahan was a leader in the Democratic Party. I was not involved in politics. I had no idea that she had a very politically connected father. I didn't know any of those things. I appeared before the board in 2011 because I naively believed that if I came here and expressed legitimate concerns that have been documented by Pachal, 2009, $150,000 report, Foley, $50,000 report. I am not making this up. There are legitimate concerns. I have been personally attacked for bringing legitimate concerns to this board. Just a few weeks ago, I attended the same legislative hearing that Commissioner Borgeson was at. I listened to them question her very pointedly about why it is that this board elected to renew a contract when it has been written about repeatedly, when Lancaster County, after Pachal's 2009 report, no longer participated in such an arrangement. A state senator commended me for being a good citizen. Very ironic, I would say. I've paid a very high price for my efforts to hold attorneys who think they are accountable to no one accountable. They do not perform work in accordance with the law and the code of professional ethics, and no one cares because it's children and it's not your family. If it were your family, you'd care. Trust me. I believe Ms. Lynch's actions cost my family thousands of dollars in additional litigation costs. I believe Ms. Lynch's actions contributed to the level of contention in the divorce. I believe Ms. Lynch needs to be held accountable. I believe her actions are politically motivated. I don't understand her relationship to Kathy Kelly or the senior Mr. Monahan or Ms. Monahan, but I sure would like to, and I sure would like somebody in county government to hold these people accountable. That concludes my presentation.
Thank you, Laura. Commissioner Boyle.
Laura, I appreciate your bringing this to our attention again, and it is frustrating because as county commissioners, as you know, we have no direct authority over the operation of juvenile court. We do have authority over the contracts that you speak of. And what we did in the last action on the contract was that we did extend the Monahan contract so that it expires at the same time as the Encontro contract, so that it will be easy if we want to make changes, and changes are needed. I think we were at fault, and I take responsibility as a lawyer for not bringing that contract back. It was enacted in 2003, and it needed to be modified. But that's my fault as an attorney for not watching that closer, and as a member of the county board, I should have observed that better. Others can speak for themselves, but that's how I feel. So some of the points you make are valid. I cringe because at some of the comments about some of the people involved, I don't think their motives are as sinister as you might think. My recollection is that while I'm an active Democrat, I don't vote a straight ticket, for starters. Secondly, I believe, my recollection is a long time ago, but I don't think I voted for the Monahan contract, and we used to office in the same building with them at Service Life. So I saw them frequently, and I know Maureen's mother and father and her brother who was disabled and so forth who died. And so I know Maureen is a very caring person, and it's bothersome to hear these things, but I think she's, I just don't like the personal mention.
Can I please respond?
Oh, of course.
I at no point said that Ms. Monahan was not caring.
Oh, I know.
I've made absolutely no comments about that. The ability to produce a coherent bill and to do your work in compliance with the law has nothing to do with how caring you are. May I please finish? Because I waited. My other comment would be, this board chose to act to ratify and further continue this contract before the audit report was produced so that the public could participate in the debate. I've made public records requests of Patrick Bloomingdale's email where he invites Tom Encontro and Maureen Monahan to his office to review the audit report, and it all seems so collegial and warm and lovely. The only problem is the public who has been complaining about this, and legitimately so, we don't have a seat at the table. To my knowledge, there's nothing prohibiting you from canceling this contract effective today. And so I take great exception to any notion that I am in some way personally attacking someone. I do not know her. I've never met her. What I do know is on my Facebook page, you won't see me shaking hands with the Obamas. I don't have any ability to get you lucrative contracts. I don't really have anything at all. I have my perspective as a stay-at-home parent who did not receive a fair shake. And the irony is these emails that were sent, I guess the county attorney has interest in free speech and what people say, which is why Don Klein's employees then are sending these faxes to divorce attorneys, I guess. But the ultimate irony is, at that point in my divorce, every person in my family had a lawyer but me. Every person but me.
Laura, if I could respond. I do think being a caring person reflects how you conduct your life, so that's what I was trying to make, the point I was trying to make. And you're seeing all these spooks in all these relationships. There is no conspiracy. There are people, I know them well, and Maureen is active in the Democratic Party, and Ann and I have pictures with various elected officials. It doesn't mean anything as far as anything to do with these kind of contracts and being connected and all the rest. Believe me, it doesn't work that way. It just simply doesn't. This board, while I have to remember what the division is, 4-3 as far as Democrats, we don't act like that. We really don't. I mean, for example, on the merger of the assessor and the register of deeds, which may seem obscure, there was Democratic and Republican votes, and I was totally opposed to it because I just didn't think it's saved any money, and I don't think it will. Sorry to get that in, but anyway, there's just no, what you see is what you get.
With all due respect, in the country, in the world, politics does work this way.
It does, excuse me, it doesn't work that way here. Okay?
And so I would politely disagree.
Well, I would politely disagree.
And my other comment is, refresh my memory, when was this contract last bid? And when Maureen Monahan, for the record, says all Douglas County can do is pay,
that's right.
Evidently the only person we can pay is Maureen Monahan and Tom and Contro.
Well, that's the contracts, and she's right. That's what the judges say too. All you can do is pay, and we don't.
How has that got anything to do with getting a request for proposal?
I'm trying to communicate to you what our level of oversight of this operation is. All we can do is pay. That is the bottom line. We don't have authority over the judges. We do over those contracts, and we're going to try to do better if they're even renewed.
Yes, and to that point, I mean, I would very much appreciate the opportunity to sit down with members of this group or the entire group. I have gone through and I have thoroughly reviewed the audit report. And contrary to what Mr. Astley may believe, I thoroughly understand guardian ad litem. And I understand it to such a degree that I've had several state senators commend me for my level of understanding of this issue. I would politely disagree with many of the things you're saying. At any point in time,
I never said you don't understand the guardian ad litem. I never said
any
that.
of you certainly could have raised the notion that this contract needed to be rebid, the notion that we would have vendors writing private emails to one member of the board saying all we can do is pay. Gosh, where do I get the $300,000 contract that never is rebid?
Laura, let me interrupt for a minute because I think, and we've talked about this, going back, and I commend you for going back and watching all that because you reminded me of stuff that I had actually forgotten about, okay? But now the point, and you did great down at the legislative chambers, and they, at the hearing, and senators were impressed. They even said afterwards that they were, because you were very succinct in what the issues were. And so Commissioner Boyle is right, and that's why we're kind of pushing the issue now, is because that's all we can do is pay. We can't even in our contracts, when you brought up the audit clause in our contract, and the question was asked why we haven't done it, did we do it, and if not, why didn't we do it? And then it became obvious that, well, gosh, how do you audit it? I mean, how do you audit a contract of services to which we have no idea whether or not the services are being rendered? And so it started this snowball of questions not being able to be answered and questions being brought up as to where we are of what needs to be changed. So I can't go back and fix everything that's happened then. When we bid the contract way back when and never bid it again, shame on us. We just kept renewing it. That's what we did. We can't go back and undo that, but what we can do is make sure that what we do from here forward is much better because of what you and Melanie and now Laura and other parents have brought forward as to what the issues are. And so that's where I'm not trying to dismiss the things that you're saying as not being important, but for me, we have to try to get over to that next hump of these are all bad. These are bad. The audit pointed out bad things, things that need to be changed. So what is it? How is it that we should work together to change the system and the GAL part of the system to work better for our families and children? So, and it's fine that we all disagree at different points. Everybody can't agree all the time. So, and you're very good, I think, at recognizing that and appreciating that. But I think what Commissioner Boyle's point is trying to be is that for right now, as the law sits, we don't have the authority, there's no accountability, and there's no transparency within this system, and those are the things that need to be changed. And that's where we're trying to work to move the system forward from where it's been in the past.
I fully support that, and you know that I am grateful for your efforts to champion this. I heard the state senators that were at that legislative committee endorse the idea that these types of issues should be discussed, that stronger action should have been taken by this body. But I in no way, looking forward and to the future and looking for solutions, should not exclude holding people accountable, particularly people who have been paid millions of dollars to do a job they don't do. There needs to be accountability, and that needs to be part of this solution. An examination, a thorough examination, because there are many things that have not been addressed by this audit report. People who accepted tax dollars to represent children who did not do their job need to be held accountable, and that is part of the solution. Part of the additional solution should be a very strong method by which children can complain. And the last document I'm going to put up, because I will be complaining about some of the things that have been done to me by some of these attorneys. The last thing I'll put up is a bit of a rule that is in the canon of ethics. Now, the notion that a child would contact the Council for Professional Discipline and prepare a complaint against their attorney who never calls them, never visits them, and never does their job is ludicrous. Me, a college-educated person, trying to put together a coherent complaint for the Council for Professional Discipline is difficult enough. I don't agree, and you know, Commissioner Borgeson, I do not agree these people need to be attorneys. But if you buy into that as an idea, quite frankly, I don't understand how you stand by and observe children who have attorneys in name only, people who do not do their jobs. The last thing I wanted to say, I know that Lori Flynn passed out a copy of Mr. Wagner's invoice. I contacted Mr. Friend. I was very curious as to how it could be that an invoice would be injustice. I have never seen an invoice for an attorney in juvenile court. And he explains to me that it was attached to the motion. So the application for fees, it's always the game. I guess I see the shadows. I'm sorry, the spooks. But it's very interesting that when the request for fees includes things like legal research in how you can suppress free speech, how you can prepare subpoenas, that's the bill that you can go find injustice. very curious that that's one, but I can't see any, and I truly have looked at thousands of cases. So yeah, I'm a skeptic. What can I say? Thank you for
Laura.
listening.
Thank you. Well, more to come on that issue. We will move to committees, the first being the finance and the budget report from Commissioner Morgan or Commissioner Duda. Is it anything or just as presented?
As presented.
And then the second is a resolution to approve the authorized 13th supplemental agreement with the Omaha Douglas Building Commission, the City of Omaha, and the County of Douglas, Nebraska. This was laid over from our Tuesday, September 16, 2014 meeting, and I know that there have been discussions in the meeting on this, and I don't know if you, as Building Commission, or Paul, who wants to talk about it. Because it's been changed, right? It's not a 25 million anymore?
Correct. The lease agreement for our consideration is now at $15 million, trying to clear up some confusion and misinformation that was circulating, that we were borrowing $25 million when we were not, and assumptions being made about the future of our capital improvements budget by people from outside of our department and what that would do to our budget. And anyhow, trying to make things clearer so that everybody is more comfortable as we move forward, we have just called it a $15 million lease agreement. That's all the money that we ever planned on using at this time on borrowing. Any more would have required permission from the county board, but in hopes that people are more comfortable, I would move approval of the lease agreement at $15 million.
Is there a second? Commissioner Boyle?
Well, I would like to ask Joel Lorenz to speak to that, because he's the one who, when we had a meeting, there wasn't time to give public notice, but had a meeting with the Building Commission folks. And Joe, would you tell us what your rationale was to try to get this reduced?
Yeah, I think in going through the discussions and looking at the Building Commission's, the room they had and their tax levy and whatever, in looking at it, we thought that by just keeping the authorization at $15 million, it would provide us and the Building Commission with the financial flexibility for things in the future, be it solutions to the juvenile court issue, improvements here to the city-county building, that this still gives us room within the levy to make those sort of capital improvements and not run up against it. So this was in meeting with the Building Commission and some of the commissioners, an agreement we came to, and one that I support at the $15 million price limit. Yeah.
Thank you. Well, I made a tour of the second floor, particularly yesterday, with the city prosecutor, David Smallheiser, and also before that with Judge Bezos. What this really amounts to, I've been through there many times when I was first practicing law and handling innocent people, trying to get them out of their situations. And there is the way it's set up, it really is, I mean, there are cells on the west end of the courthouse, and there's a courtroom where you walk right in next to prosecutor's offices. The prosecutor's offices are, the number is correct. There are 12 offices. There are cubby holes. They're in bad shape. There's no question about it. There's mold and all sorts of things that need to be taken care of. And it's not an ideal situation. No one would design that facility today. There's no question about it. So I can understand why they'd want to get out and have everybody lined up in one place and all that sort of thing for convenience. I know that the former city prosecutor was kind of devious. He held staff meetings at 4 o'clock in the afternoon. So he made sure everybody was there and working. And I don't know if they still do that. But anyway, it really, and then the judge, I talked to Judge Bezos, and both of them told me that a lot of this hinges on moving a courtroom, and I don't remember the number now, I think it's 26 or something, 28, I'm not sure, moving it up to the 6th floor. And I asked David, I said, what is the thinking behind that? And he said, well, I said, you're going to move them up with the juvenile, we want this should be moved up with the juvenile court? And he said, well, I kind of shrugged, and I said, do you think they're moving? And he said, well, yeah. So they're counting on, this whole thing is moving that courthouse with a high risk trials, and we know who we're talking about. That would be moved up to the 6th floor, which would allow quite a bit more security, apparently. But this is hinging on the juvenile court moving, and from what I hear, we've got about a 2% chance of getting hold of a building that apparently most people want to get a hold of. So I'm real concerned about that. I don't know if that's going to happen. I think what we ought to be doing is building a high-security jail or using the one at the correction facility for these trials. When I went through with Judge Bezos, she was talking about putting up a glass shield. There are fights in the courtroom. Witnesses show up, family members are there. It gets pretty chaotic. And there have been incidents, no question about it, but there are confrontations frequently. If there isn't one, it's unusual. And I know that judges have been almost attacked. So it is a serious matter, but I think remodeling that would probably help. Unfortunately, the place is a mess. It really is a mess. So something has to happen to it. Either we go in and clean it all up and put it back like it was, or we go through with this movement, which to me, it's really the same. It's the same place, just kind of moving offices. And I don't know that it's. I don't know if that's good. But I will tell you what changed when I went through with Judge Bezos was the issue, and Mr. Smallizer, was the issue of security and the way that the judges' offices will be put in one place and there would be a corridor for them to enter and exit. I think that's good. I like that. I guess I've become a reluctant convert to this second floor renovation because I think it is a mess over there, and I think for security purposes it probably needs to be done. Having said that, I'm really concerned about this courtroom moving up to the juvenile level if we don't get the juvenile court out of there, and I don't see that happening. I think what we ought to do is step back a little bit, ask the building commission to work with us to either, if we can't use the courtroom we have in the correction facility for these kinds of trials, which is very secure, it has a glass box, the public can be present, and the defendant can be behind it. We've all seen it. It works well. It's very much accepted by the judges who appear there. Either we start using that for the high security trials, or we, if we have to, build a separate courtroom attached to corrections that is high security. It would mean those prisoners wouldn't have to be transported. They wouldn't be in that building at all. But I think we need to rethink that, and I think especially what we ought to do is start talking about using the existing courtroom we have in corrections for these trials. And it does have to be open to the public. Well, people come in there all the time, and the nice thing about it is they're screened. They come through security. We know that they have no weapons when they get in there, at least that are of metal. And they are sitting behind a glass area. They can hear what's being said, but they can't jump up and, run toward the judge or anything like that. It's very secure. That, in a nutshell, is what I think we ought to do, and we should be very careful about approving a renovation on the 6th floor for a courthouse when we really don't have any plan to get that juvenile court out of there. And the other thing I worry about is up at the top of that 6th floor, I personally have concerns about exit in case of an emergency. I'm not sure, and I suppose I'd ask Paul to speak to that about the emergency exits and how you get out of there, where the staircases are and all that. I've never used them, and maybe they're really fine. I don't know. But having said that, I will vote for this renovation. I'm reluctant. I know that I told the judge and told David, I said, well, at the beginning of our tour, I said, I've got to tell you this, don't be concerned about this. It's going to pass. It's probably going to be 6-1, and maybe it'll be 7-0. But I said, I'm concerned. So having taken our time, I I will probably vote for this. I'm still kind of wobbling, but I think the second floor, the judge and David convinced me of the need.
Well, I kind of agree with a lot of what you said. What I think is, I mean, I'll support the motion on the floor today as well, but I think we're missing the boat on a couple of things, and I think that the conversations that didn't take place with the city prosecutor and the county attorney should have taken place, which probably could still take as we look at what the renovation would be. There has been talk for 3 administrations about combining the city prosecutors and the county attorney's office. And this would have been a prime time to have some further deep, serious conversations about that. And even if it was a reluctance of co-locating at this time, it would have been the first step in bringing them together to maybe have some more serious or better serious conversations about it. So I hope that that can still occur, even though we're a little bit down the road here. And then I also just find it ironic that for the last 12 years we've talked about putting the juvenile court over at the youth center, and now all of a sudden out of the blue there's not enough room. And I just find that suspect. I just not sure why that's the case, other than there's another building that everybody has their eyeballs on. And so yeah, I hope that we can still have that discussion, because when you talk about transporting the children and kids and having to put them in shackles and all of that to bring them over here, having it right there at the youth center makes a heck of a lot more sense in efficiencies, and I think there would be huge cost savings, and security issues would be addressed as well. So again, it's easy to be the Monday morning quarterback on things, but I appreciate the ability to provide our input as we potentially move forward with the bond issue. Commissioner Boyle?
Well, I agree with what Commissioner Borgeson said, and I am fascinated by what happens with Lincoln, where they have some 40 buildings apparently in their stockpile. And they even had built a building that stood vacant apparently for a year. And I'm interested in it because I think that's a better model. I think if we move juvenile court to, I guess, to an off-site out of this building or out of this complex, I'm curious about how the building commission can do that, because I thought it had to be a city-county operation. So that's a question I've got. I hope someone can answer. It will answer. And if we can do that, then I think what we ought to do is start talking about doing what Commissioner Borgeson suggested, and that is build a courthouse and whatever is needed over there at 42nd Street, and also discuss seriously the use of the courtroom we have in corrections for high-profile cases. It's a matter of security, and that really is high security. And I think that would, if we get rid of that courtroom up on 6, that's supposed to go up there, and instead decide we're going to use the courtroom we have in corrections, I think that'd be a step in the right direction. But I want to say something else. I do appreciate the work that the Building Commission does. This has taken on a kind of us versus them, and all I'm trying to do is ask questions, and you know, I appreciate the work that's done by the Building Commission. It's been a terrific asset for us, and I appreciate the service of the commissioners who represent the county and the city, and Mr. Roskins as well. So I want to make that clear, but I would like some serious conversation about using that courtroom in corrections and forgetting about moving that courtroom up to juvenile court. And then I think we seriously ought to look at doing some things to move the judges over to 42nd Street. I think we ought to explore that. Thank you.
Commissioner Duda?
Thank you. I'll try to respond to a few things. I really, if I was wise, I'd just shut up, because people are, it's kind of tepid agreement, but I'm hearing a little bit of agreement here, and I appreciate that. We are trying to move forward together. The idea of a juvenile justice center at 42nd and Woolworth, Our public properties have been telling us for quite a while that we really don't have the room out there, and that if we do try to put, if we did try to put something in, it would have to be high, and that makes it more expensive just because we don't have that much space to work with. With regards to merging the city prosecutor and the county attorney's office, probably a fine idea. They have great cooperation right now, but that's not the building commission's role. The building commission runs a building, doesn't tell the occupants how they should be functioning or merging. That's between the city and county, between the county attorney, city prosecutor, us, mayor. Those are the entities that need to get together if we want to merge the city prosecutor and the county attorney. If we are successful, the building commission will accommodate with the offices that are appropriate. As you saw with this bond issue, Building Commission really has pretty limited resources, and of course we voluntarily keep our tax rate at 1.5 cents rather than the 1.7, which we would be capped at, and that's what Lincoln Lancaster is at, and that's a little bit of what allows them to have so many more buildings. We don't have the financial wherewithal. I mean, as we saw with this, a $25 million bond issue was going to tax our resources. We could do it. We were comfortable. Bruce Leffler is here. He helped us with a lot of this. We were comfortable that we could move forward with that. However, if you start talking about a new juvenile justice center or something, we don't have the financial wherewithal to do that. If you didn't think we could afford this, how do you think we could ever afford to do that? That's just not within our financial means. So,
Commissioner Morgan?
Well, I think we ought to, at this time, what Commissioner Borgeson said, Commissioner Boyle, at least make sure we have discussion of this board about those options and find out if it's possible now rather than later and move toward that. I also think we should be trying to figure out what offices are in this building that could go out to 156 in spaces that we have just sitting vacant out there. And we're going to be doing hopefully some things out there, and make sure Jerry Leahy and others are involved in that discussion, and then go to wherever we need to go with the city to see what we can get done, and not just talk about it, but if our chairperson initiates some of those meetings, I think we need to at least ask questions, and then however the majority feel, we move in that direction. And I think on 42nd we can go back and forth forever, whether there's space or we'd have to go high or whatever. At least look at that idea and see if it's possible and feasible and affordable, and go from there. So, and if we need to have some special meetings that are open to the public on those things, and I think they should all be open, let's get with it and do it now while we're not in budget times and so on, and start meeting this fall to do some of those kinds of things to find out. And I'm glad to meet with the city at any time you suggest to try to do that, or be on the sidelines and come back to us with it.
Okay. Commissioner Boyle?
Well, I appreciate the conversation heading the way it is, and I agree with Commissioner Duda that it is, if you can't afford this, how do you afford that? That's right. And I think one of the ways is to cancel that courtroom up on 6 and direct that money toward something else. It opens up a pot of money that we could, if we could just mimic Lancaster Lincoln on what they do. I don't know how their statute is different than ours, but that would allow us to at least maybe renovate something in the youth center to give us a courtroom, for example, it would take the pressure off at least one courtroom, maybe more, excuse me, over there. But that's something that I think we should look at. And I also appreciate what Commissioner Morgan said about moving the offices. I have felt for a long time that one of the ways that would clear up space in this Hall of Justice is to move the people who are there that are not, kind of the back office people. For starters, I think that, I don't think it's unreasonable, and this will probably really freak people out, but I don't think it's unreasonable for the city prosecutor to be moved out. I mean, the prosecutors come in for the cattle calls, and they're in there at 9 and 1 o'clock, and the courtrooms are full, and they go through the whole thing, and it may take 2 hours for the people to plead. And then after that, they could go back to an office in an adjacent building, and that would clear up that whole west side for whatever it is that they need. One of the things is that you know, this really doesn't add any space to anybody, this renovation, and I have some difficulty with that, but again, it does need to be cleaned up. But I think we need to look at long-term, talking about moving some of these back office operations out of that building to extend the life and then remodel it based on what it's supposed to be, a courthouse. With courtrooms and really great security for the judges, it could be an ideal place and it could look great, and I think that's where we ought to go, because it's that would really be, I think, a solution. That's my thought.
I think, Commissioner Rogers?
Yeah, I mean, the context of the this other juvenile facility, I still don't think it's limited, because there was not going to be, there was a lot of ways talked about in regards to finance, and it wasn't the fact that they thought it would solely be on the county, and there's been vague conversations with people in making that happen. In regards to the space, the issue with space, I mean, the whole conversation originally started by asking what could be done with existing buildings out there to get them out the way. So I don't think the conversation is dead, and because it never talked about traditionally having it all on the back of the county. And so I think we shouldn't limit ourselves in that. I think you should just move with this and still have that on the table, because I think there's still options out there to make it happen. Yeah.
I agree with that, Commissioner Rogers, but that's the point was, and you know, I kind of agree, it's probably better to shut up. That was the whole point here, is that we didn't get to provide our input to the plan, and now it looks like we're trying to be obstructionist to it, which is not what is happening. But those discussions, I think, are, and I hope that people are listening, is that those discussions should, and I hope, take place, even though we're this far down instead of this far down. It's too important to, I guess, a plan, and it's news to me that our own public properties has said that there's no room over there a long time ago, because we have talked about this every single year at some point, and everybody's just nodded their heads, yeah, someday, and that's all we've ever said. And then the building commission not having the function to discuss whether there should be a merger or a co-location of the city prosecutors and county attorneys. If we would have known this was happening, those of us who have worked on that for the last 3 years could have kind of spearheaded those discussions. Not that it would have happened, it's just that they kind of lay low, and then we talk about it, and then nothing happens, and it goes back down. And so this would have been the prime time for us to have those discussions, to say, hey, maybe it is maybe bringing in the space concerns in the civic center, trying to figure out who we can move out to 156 and moving all of those people over here in a co-located area. So again, it's not, I do not want this to be that we're trying to obstruct, but we didn't have the timing, unfortunately, is what it is today, that we're now all of a sudden coming up with these bright ideas.
And I was mentioning more so in the context that, and I don't know where it got cloudy to some degree, but I mean, which is a whole nother, I brought the juvenile justice piece up because there's a whole conversation about the courthouse in itself. And I know there's like this big taboo issue of not having a new courthouse, but if you're going to avoid a new courthouse, something's got to give, and that's where this came from. So, no, I'm with you in some respects. I'm just saying we shouldn't shut it down, and if we're there, we should just willfully move forward after this is done and make it exhaust all means to either take it off the table or see what can happen.
Commissioner Boyle?
Well, I'd like to ask Paul Cohen to come to the podium, please. I have some questions. And first of all, you've heard what Commissioner Borgeson said about if we had maybe if we could back up a little bit, excuse me, and go into and talk about some of the things that have been on the table for 3 and 4 years. You know, for example, talk publicly about Mr. Leahy said about there being no place to do any renovations or add any facilities or courtrooms over at 42nd Street. And I'd be interested in also having you comment on what is it that Lancaster Lincoln can do that we can't?
That's a whole different...
Paul Cohen, Building Commission Administrator. I don't know that I'm prepared to answer that question, Commissioner. I think it's a matter of longstanding philosophy that we've kind of inherited here. Lancaster-Lincoln was the second building commission in the state. We were the first. We were the 55th in the country. They were the 56th model. The model started in 1956 in Detroit, strangely enough. And that model has been adopted across the country. There are currently 36 that are similar to ours. But that is a background. Lancaster-Lincoln, in their initial discussions, elected to keep their levy at the maximum, and it's gone up over the course of history from about 1.1 cents, actually it was less than a penny when it started, to currently 1.7. And they have always maintained their levy at 1.7 cents, even when they didn't have projects or bond issues or what have you, and so the cash reserves were considerable. Our commission, over its 40-year history, has taken a different view, and that is to keep the levy where you need it to be in order to take care of debt service, because that's the only thing you can use the levy for is capital improvement and capital expenses. You can't use it for operations. Operation money comes from what we call rent. So I think that's been a substantial difference. And yes, they did build, their city-county building was built with 5 floors. They had projected at the time that that would be good for a 5-year period, that they would have sufficient space for 5 years, and so they purposely left the 5th floor of that building, by their own admission, vacant. At the same time, city and county facilities were renting space outside, and at the end of the 5 years, they then filled up the 5th floor. I'm not going to judge how they run their operation. They do some really great things, and the administrator is a great colleague of mine, has helped me a lot in trying to figure out how to make this work over my initial stage here and after. It's just different. The thought process is different. The process of building city and county facilities always involves the building commission trying to find a way to utilize the resources that may or may not be available. And they have, because of their taxing philosophy, accumulated significant dollars to do significant things, including building storage space that they rent to the state. And we've elected not to do that for whatever reason.
Well, and I can understand that philosophy, and I agree with it to an extent. I think they've managed to do something that I think we need to do to some degree. I don't want to go out and build buildings to rent to others or build buildings that are vacant and all that stuff, and I'm not totally criticizing them, but what you say is kind of makes me a little nervous. But I think there are things that we could do that would be to expand our mission perhaps, and at least join this, have the city and the county join in a conversation to say, you know, we think this is a good deal. In my office, I asked well, I guess I do have a map in my office, but also one out in the public area that shows all the city offices, where they're located, and city facilities, I should say, including parks, I suppose. GIS prepared that. Then I have one that shows the county and what the offices are. And there are some interesting things. There are clusters of county operations, and there's city nearby. And I'm looking forward in the future to try to figure out if there's something we can do to either build a facility so we stop paying rent at our, probation office, for example, and we merge that with the city facility. I don't know what that might be. Or maybe we merge it with a county operation with the DMV or something. I mean, I think there's some ways to save money. It's long-term, and we probably can't do it. We would need the building commission's help, and I think this is where this would make some sense to look into that, at least, about merging city-county operations into one, because I think eventually it's really heading that way, that some kind of a metropolitan government's going to take place. I mean, there's hardly, the county territory is diminishing. I think we're down to about 90,000 citizens that don't live in an incorporated area now. So anyway, that's in the back burner in my brain. The other thing I really want to go back to is what Commissioner Borgeson said about having something to say about these other possibilities that we've been working on, and really having a working relationship with the Building Commission, that we can talk to you, and I know we can, but to have formal discussions in the public about what possibilities there are and how we might be able to accomplish that and what it might cost, whether it's realistic or not. And I think it may, if we start reducing rent and doing, it's a possibility. I don't want to drag it on. So I am going to vote yes, Paul, in spite of what you might think. I'm not throwing darts. I appreciate your leadership. It's just that it kind of caught us by surprise a little bit. And
let me comment on that, Commissioner.
Yeah.
We apologize for that.
Well,
we thought we had the bases all covered, and we did not. And that I'll take. Someone talked about accountability before. I guess that's my problem. So it isn't, but it's okay. I do apologize for that. We have had a long-standing, outstanding relationship with the county and the county board and your administrative staff as well in over more years than I've been here, and we want to continue that. We don't want anything to get in the way of that, and that we apparently disagreed. That's business. Let me comment on the sixth floor to clear something up here. The proposed courtroom on the sixth floor does not impinge on the juvenile court area. In fact, sight, sounds, and physical separation is maintained. So it was never predicated on the sixth floor being vacated, which would really be cool if it was, but it was not. And so that courtroom will be constructed separately and totally separate from the juvenile court area. It just happens to share an elevator to get there. But we're assured by the security folks that that's minimal problem. So and I think the plan showed that. Might not have been too clear in the plan. But we will, however, before we take one concrete block and try and do anything with it, certainly have the conversation about, is there another way to provide that particular court, perhaps in the jail, perhaps somewhere else, before we do that. And we'll keep you informed as we go through that process. We'll let you know how that works out. That's a fair comment, and we welcome it.
Madam Chair, may I?
Yep.
First of all, I thank you very much, Paul, for what you said, and I appreciate your being gracious. Thank you. The other is, what space is this courtroom on the sixth floor going? I'm really kind of baffled. Is it going over to the west side someplace in the county attorney's space?
Help me with the directions. Is the west side? It's over on the west side. It'll be constructed where there is now a holding.
Juvenile court.
Is there a holding cell there?
It's
Can you come up?
Yeah, come on up, Wayne.
Say your name and all that sort of thing.
Captain Hudson with the Court Services Bureau. Where the courtroom is going is currently the area where the deputies' break room and locker room is. So that's going to be relocated to the courtroom.
Really big space then.
It's a fair amount of space.
I'm joking.
But one thing I need to clear up, though, as far as it's not going to be trials in that courtroom. It's going to be preliminary hearings. We can't have trials in a jail setting. The courts won't allow that. So it's only the initial preliminary hearings that will go up in courtroom 25.
I see.
And sentencings. And the reason why you can't do the preliminary hearings and have it at the courtroom at the Douglas County Jail, because that jail is going to be used at the same time. So when they're having preliminary hearings, the courtroom jail is also in use. So you can't use them both at the same time.
Well, we could if we had a judge working after 4:30 in the afternoon, which we've discussed. Which is another hurdle. But, excuse me. So we would have people who are, you'd have people in adults in chains, I suppose, riding those elevators from where to the sixth floor. And how do you, when they doors open and hear some kids coming down, I mean, I don't get this.
It's sight and sound separation. Up on the sixth floor, you have a area for juvenile inmates and you have adult inmates. So they won't cross in the hallways, they won't be seen, they won't be heard.
Okay, but you're sharing the elevator, right?
There's only males or females, adults in the elevator at one time, or juveniles in the elevator at one time. We don't mix juveniles and adults at the same time in the elevator. No. In the jail elevator.
You're talking about the 3 elevators that...
No, we have our own separate secure elevator.
Okay. I'm sorry, I don't know about that over in the corner. All right, well, I appreciate that, and I'm still trying to figure out, well, if the juvenile court is going to be getting another judge, it seems to me like that they ought to have first dibs on that space. That's what I'm wondering, and I'm concerned that that moving them out of the building, I mean, I don't have a problem with that, and I think they apparently like the space that's been suggested, but I don't know that we're going to get it from what I've heard. How do we work that out?
Paul Cohen, we have not addressed the sixth judge, but let me and that's part of the problem with the sixth floor. It's why we have to find, I think, personal opinion, not necessarily that of my management, we have to find a solution for the juvenile court space. We just do, somehow. We can't put the sixth courtroom in the same place that this is going because of sight sound separation.
Okay.
You got to keep them physically and all separated, and so it can't go there
from adults.
Right. There is no way physically, without tearing the whole floor apart, and the holding cells are in the way, to get a sixth juvenile court on that particular side.
Okay.
Otherwise, we would be having a different kind of conversation. But we really need to address that. I don't know where the sixth judge is in terms of when or if it's going to get here. All I know is what we've been asked to look at. We'll put that on hold temporarily. We're going to have to come back and visit. We're going to have to work with you to figure out a solution to that problem, because it gets a little more critical every day. Captain Hudson's got people now spending much more time in the juvenile court area trying to keep everybody separated and happy, and we really need to address that.
And you're talking about this last comment, separated from adults?
Yes.
And not necessarily parties to juvenile action?
I'm sorry, yes, parties to juvenile action, not from adults.
Okay, so get a little more specific about that, one of you, about what do you need that additional security for? Are there gang members up there or something, or what are we talking about?
Well, you have all kind of contentious issues in juvenile court, especially when you're dealing with judges taking kids from parents. So we have to have extra deputies in the hallways, roaming the hallways, things of that nature, and because of the space they have up there and the limited space that they have.
Well, let me ask you one other question that's a little unrelated, but why are children brought into, and who does this, why are children brought into the courtroom for hearings and, I mean, really chained up? That's just really says to the child, you know, you're a criminal. Why are we doing that, and who's doing that? It's not you. Is it the youth center? Who is it?
No, it's my rule. It's from the sheriff's office policy. It is. It all depends on the charges. What we have found throughout the years is juveniles like to run. They like to run. They like to fight more than adults, because adults are older. So what we do is we put them in leg shackles and we put them in handcuffs. The handcuffs come off once they go in the courtroom, unless they're facing murder 1, murder 2, manslaughter, or any type of violent crime. Just to mention, we had a 14-year-old who stands about 4 feet tall who was in there facing murder charges. He's going to be in full restraints based on his charges.
Okay, I was really thinking of a young man who was charged with assault after he'd been called a racial slur, and he was in full chains. And he had been through 17 foster homes. And bright young man, I got to know him a little bit. He was in this situation, and I was stunned, because I didn't think, it doesn't seem to me like slugging someone for calling them the inn name was raised to the elevation of first-degree murder. I didn't get that.
If we have someone who's in full restraints, they have to have some type of assaultive behavior. We communicate with Douglas County Corrections and the Youth Center just to make sure that we have the proper security precautions in place for each inmate.
Okay, we'll talk further. I'm sorry to divert, but as long as I had you here, I wanted to ask you.
No problem.
Okay, well, I'm kind of through with my comment. The only thing I want to say is that some of this, I believe, the Farnham Street level where the judges' offices are will be vacated. Is that correct? Okay, so how does that work? Because aren't there some courtrooms? I don't practice in county court much anymore, so are there any? There's a couple of courtrooms on the west side, aren't there?
There are 3, 4 over here.
So those will
remain. Talking about those here in the
right.
They'll remain. They're mostly, not totally, but there are no criminal cases in those courtrooms any longer. They're all civil.
Okay, so the courtrooms will remain, but the offices will go.
Pretty much.
So are those, my recollection is that the offices are adjacent to courtrooms, so they'll be kind of chopped up vacant space, right?
At the moment, that we have not addressed that with the courts as to what they want to do with that space, but yes.
Okay, well, maybe there's some way to use that for some of their operations to get them out of the Hall of Justice.
Right.
Just a suggestion, but, and we'll get to pay for that, so. Thank you very much.
Sir.
I appreciate, for me, the information. Thank you.
Commissioner Duda?
Thank you. Just a couple of quick responses for a few of the things brought up here. This is a 3-year plan for the Building Commission. I mean, from the time we issue the bonds, we have 3 years then to expend the funds. Nothing is happening overnight. If the city and county can start making progress on merging the city prosecutor and county attorney, and the city and or county come to the Building Commission and say, hey, there's a chance we're going to be able to make this happen, the Building Commission will accommodate. But without that, without somebody giving us notice that there may be a change coming, we'll proceed with things as they are. But we have time to adapt this. Nothing is cast in stone. We're presenting a general idea of what we anticipate taking on in the next 3 years. With some professional guidance. We're trying to show you we're not just asking for money. This is what we have come up with. But there is still a lot of flexibility, and every year the Capital Improvements Committee gets together and prioritizes, and Joe Lorenz is on that committee, prioritizes where the greatest needs are right now. So I can assure you, if we can make progress on merging the city prosecutor and county attorney, the Building Commission will do everything that they can to accommodate those changes. The juvenile courthouse is a huge issue, and absolutely we need to be figuring it out. I don't know of an easy solution. I don't frankly know of a good solution, but it is a looming problem, and it frankly is more the county's problem than it is the Building Commission. We'll work together if we can. But at the end of the day, the county needs to come up with our own plans long-term for what we intend to do with juvenile court and how we intend to pay for it. The Building Commission will do whatever they can in support, but it is a big problem that we do need to be vigilant towards. Thank you.
Commissioner Boyle?
Well, I'd like to ask if it's possible, since this is a 3-year plan, if it's possible for the questions that Commissioner Borgeson raised, and maybe I'd like to ask her to revisit those for a couple seconds. Tell us, is there time for us to consider what she's talked about? What were those?
We could have the discussion to see if the will is there at this time with the city to talk about bringing together the county attorney, the city prosecutors under the county attorney. We can have that discussion again.
Right.
And see if the will is there to proceed down that road. That's, I think, a pretty easy one to get done fairly quickly. The other is, I think we need to revisit what has been on the table for many years about some type of justice system over at the youth center.
Right.
If it's now not feasible, then it's not feasible, but then get it off the shelf and say it's not feasible. Then the 6th floor, I mean, Senator Chambers, as long as he is in the legislature, he has vowed that we will not get another judge.
Right.
He said that at the hearing the other day.
Pending a resignation. I mean, there is an outside chance that it could things could change potentially.
That's true. Yes, thank you. But on the 6th floor, where the juvenile county attorney's office is, that space was designed to be the space for the next judge. So there is room up there for another juvenile judge. But that doesn't mean that we just stop talking about, some other location for the juvenile court. But if worst comes to worst, it would be the juvenile court county attorney piece that would be moved out and the judge would go in there. That's how it was designed to work. So, again, I think we have time to discuss those things, and also your idea of using the courtroom over at the jail. And maybe we mimic that over at the youth center in some way, shape, or form. So anyway, those were the 2-3 things that I think would warrant some further discussion at this point.
Okay, if I could, I'd like to see us, someone on staff, make notes of this, and I'd like to see us begin that discussion. I frankly feel that the merger of the city prosecutor and county attorney is really similar to the register of deeds and the assessor, where the only thing that happens is the city prosecutor doesn't exist personally, because the same number of people have to be there supposedly, and so I don't really know that that makes a lot of...
Salaries, there's a lot of savings on salaries.
Is there?
It's been
Okay,
looked
well...
at. It's been looked at.
If you bring some
As much as I want to discuss this, I don't think I like where this is going. No.
I know. It's just that
I understand.
we could talk about it.
All right, but well, if staff would make notes of this, and I would like to see us begin this discussion to see whether or not it's possible. And Mr. Leahy, of course, would be involved. I'm really wondering out loud whether the courthouses that are in this building are really needed. I hate saying this. The judges are probably flipping over on their seats right now, but I really wonder whether we need all those civil courtrooms. I mean, I did practice there, and I had trials in most of those courtrooms. The one next to the office that goes through the security over there where the civil clerk's office is, there is a lot of action in there, there's no question, but there also are used. But I wonder whether we need all of them. Do we really need them? If we don't, we could clear that out and move some staff in there, and I think it would really work well. I just suggest that. So I hope we can talk before this thing is really set in concrete. It's kind of hardening rapidly, but...
Well, I think the other point that we kind of batted around after the last discussion on this in the courtrooms was to bring up again the conversation about a night court or weekend court. I know those are evil words, but you know, times have changed, and that actually could potentially help with our space needs as well. Right. And that could be easily held over at the corrections facility. So that would be the fourth item to which we have a conversation on.
Thank you.
With that, if there's no other discussion or conversation, Laura?
A night court would be a fabulous thing. Many people who struggle to come to court and are trying to work, and they find it very difficult to pay to park down here. They have to take time away from work. But also, I'm vehemently opposed to any improvements until the judiciary comes to the table and addresses the lack of transparency and accountability issues, particularly in the juvenile courts. As it relates to shackles, I'm familiar with the case that you referred, Commissioner Boyle, but I can also tell you my eldest daughter and I, before she went away to college, we were observing random cases in the juvenile courts, and I saw a young lady who was about this tall, pink jumpsuit. Her crime, she missed 29 days of school, and she shoplifted something, I think, less than $200. She was in a pink jumpsuit, arm shackles, leg shackles. I am vehemently opposed to the shackling of children, especially young children. I think it's wrong, and I think that it's a disgrace. We need to do something to change that. I think it sends a strong message to the child and also the rest of the participants. I can also report Melanie and I have had conversations with Mark LaFleur, and I believe that he recounted that all children are transported in shackles to their court hearings when they come from the DCYC. And by the way, that young lady, Truant, she copped a plea for her shoplifting. She was incarcerated in the DCYC for 2 months for missing school.
Thank you, Laura.
Real quick, if
State
the person's
your name again.
Wayne Hudson, Court Services Bureau Captain, if the person's in a pink jumpsuit, then that's a truancy deal. That's not the Sheriff's Office transporting them. That's Douglas County Youth Center. So you have to take that up with Brad Alexander. And as far as, just to make clear, we bring all juveniles that we transport over in leg shackles. They tend to run. It's a simple policy.
Okay.
We'll talk about it further.
Okay.
Got a lot of questions.
Conversation that I think we definitely need
Paul wants to know, don't you?
talk about. Okay. With that, there is a motion and a second to approve item A2 in our Finance Committee agenda. And that is authorizing the 13th supplemental agreement with the Omaha Building Commission. Please vote.
Motion passes.
With that,
Mr. Borgeson?
I'm sorry, Commissioner Boyle.
I would like one additional comment, and that is to publicly thank Joe Lorenz for putting pencil to paper.
Yeah.
He's done an excellent job as our finance guy, our bean counter, and he's just really a real asset to the taxpayers of Douglas County, and I want to thank him publicly for his work on this. Thank you.
That's a very, very good point, and I ditto that comment. After, we'll move to Human Resources, the weekly personnel report from Civil Service as presented, unless someone has a question or comment. The weekly CAO report on staff assaults.
Nothing to report.
Legislative issues, we'll be preparing, and well, it's actually prepared and just needs to be sent out, is Marcos has done again a fantastic job of capturing all legislative issues of which we've kind of blurted out here at the board meetings from time to time, and other issues that people have sent in to put together our legislative agenda. And what I've asked him to do, we don't meet next week, right? Or is it the next week?
Honestly.
Next week we don't meet?
We meet next week.
We meet next week. So what I would like Marcos to do for us is to do a presentation at the podium for us and walk through those items, and then we would preliminarily approve our legislative package to take to our tri-county retreat, which we know, or in knowing, that could change potentially between now and the end of the year, but at least we would have an approved legislative agenda to begin talking with the other counties on the 23rd. So that will be a presentation next week. And that's all for legislative issues. The next is a resolution increasing the county's employee medical insurance premium by 8.1% and increasing the wellness benefit, and I think it was from $250 to $500, both to be effective January 1, 2015. And Patrick, this also then includes adding 2 cancer drugs to our coverage, is that correct?
That is correct. Breast cancer prevention prescription drugs to be added to the coverage.
And there's 2 of them, and at this point, there's not, or could be a nominal, however that is defined, cost to the county. Tracy, can you come up and maybe just real quick, when you say nominal or little, or what, does that range from $0 to $100 or $0 to $100,000?
Sure. I'm Tracy Krause. I'm from Aon, 11213 Davenport Street. I did respond to your question last night. It was late. United Healthcare has never given me any dollar amounts of the 6 members of your group that are taking the medication. So when the mandate came across, what it says is that effective for renewals after September 24th of 2014, so it would impact your 1/1/15 renewal. Any plan that's not grandfathered, which right now would only be your high deductible health plan, has to provide the coverage for those 2 medications. So you don't have a choice on your high deductible health plan. You currently don't have anybody on that plan who's using the medication. Of your 5 members, 0 are on the HSA plan.
Right.
United Healthcare hasn't given me any data. I did go back and pull some other data from another carrier. You're talking about 16 prescriptions that range in about $331 year to date for that particular group. So I guess I didn't know how else to define it as a nominal cost.
So would that be $300 for the total 16 or
for total?
For total, okay.
Total.
So that's pretty
right.
nominal. Okay.
And to give a better idea of how it's kind of harder to give you a number, your current renewal is 8.1%. For every 0.5%, it equals about $150,000. So even if the drugs were to go to $150,000, it would only take your current renewal from 8.1 to 8.6.
Okay.
So that's why it's so hard on your $26 million of spend. adding these drugs. Now, I guess the question is, you only have to add it to the high deductible health plan.
Right.
It would be our recommendation, as we've implemented the wellness plan, to add it to all 3 plans so the coverage is consistent on the prescriptions.
Well, and I think the drugs that we're talking about are extremely effective drugs and should be on our plan.
And
So,
again, it's only for prevention.
Right.
So unfortunately, a member who's been diagnosed with breast cancer who's taking tamoxifen would still have a cost share.
right.
It would be those people who would qualify for the preventive medication piece of it that would have no cost share of taking that medication.
Okay. All right. So, again, there's a resolution. Our premiums would increase by 8.1%. The wellness is $250 to $500. Is that the recommended
Correct. On the
increase?
$300 plan, you're moving it from $250 to $500. On the $600 plan, you're moving it from $500 to $750.
Okay.
And that's just to get increased wellness participation. In 2013, only 31% of your members got a wellness exam.
And
So hopefully by
we're
giving them
hoping
a-
with our new vendor that increases as well. And then, again, adding those cancer drugs to all. our
3 plans effective 1/1/15.
Commissioner Boyle?
I wanted to ask if, on that service, are we treating all employees equally? Did I hear you say people who already have cancer have to contribute more than people who are using this to prevent it? Or is that what-
Correct. Healthcare reform only really addresses preventive care. So for anybody who would qualify for taking that medication as preventive, those would be the ones with no cost share.
Okay, so we have a decision, we could say that we would cover the people who already have it. It seems to me to be a little heartless that we say, well, if you have it, you're on your own, or you contribute more than people who are trying to prevent it. Why are we doing that distinction? Money?
No. First it was the state mandate that required it to be on non-grandfathered plans. However, you can't always just cover things at 100%. For example, those members on your high deductible health plan, they can't have any first dollar coverage unless it's preventive. And that's an IRS guideline.
Okay.
So,
But I mean, we can't, to me, it seems like the county has always controlled what we cover, and regardless, I mean, we just didn't pay any attention to anybody else's, restrictions, because we wanted to add, chiropractic and so forth and other things, acupuncture, things like that. And without regard to what else is offered, are you saying that we can't do anything about the people who already have cancer?
you could, Commissioner Boyle, but where would you draw the line? I mean, why are you only giving 100% of care to people with breast cancer, not cancer of the liver, cancer of the pancreas, lung cancer, things like that? It would be harder to draw the line in that cost share of what conditions were approved for no cost share and which ones weren't.
I'll look into it further, but I appreciate it.
Absolutely.
I wanted to ask you, what are we doing about autism? Did we, there's a lot of conversation about parents having access to care for autistic children. Are we, what are we offering and to what limit? I've read recently about some terrific experiences. I think it was in the New York Times about a family that I think she spent $65,000 and they lost their house and I don't know what all, getting their child some special care. Can you comment on, do you know what that care is, and are we going any place near that in coverage for the county employees?
Coverage for the county employees is already included. It's essentially mandated for you because you're a county government, and we did build that into our projections. It's about 0.5%, so that additional coverage we factored into about $150,000 for your projections when we do your financials.
Do you know the treatment I'm speaking about? Okay, is that being covered by Douglas County?
Not now. It will be 1/1/15. It's called ABA therapy for autism.
Okay, it's really sounds pretty terrific. Then I wanted to ask you about something a little more controversial. How about children who are having seizures and their parents want access to the marijuana treatment? There's no way that we can do that, can we? Okay, we can't. Well, I mean, I'm asking, can we possibly? Read about parents who are desperate. Is it a possibility that we can discuss and perhaps assist them if they go to Colorado? I mean,
no, your plan design has a limitation that anything that would be not FDA approved or investigational or experimental would not be covered. So
is that experimental?
Unless the FDA were to approve the use of marijuana for that condition, it would not be covered underneath your health plan.
But Senator Crawford has a bill that she will be introducing, that she's done a tremendous amount of work over the off legislative session about that issue.
Mm-hmm.
I don't know what the bill is or what it looks like or what it does. I just know that she's been very engaged with parents on that issue, and so we should be
I'm planning
seeing
on
something.
I'm going to personally
soon.
testify in favor of that bill. I think it's terrific she's doing that. I had one other question. Have you heard of a company called Zenefit.com?
I have not.
Okay, well, they do what you do on the internet, and a pretty fascinating story. You might want to look it up. Thank you.
Okay. And the autism coverage, that it's also the state, the parents were trying to get the state to have Medicaid pay for it.
Right.
Which is kind of in a mess right now. So, okay.
Thanks a lot.
Is there a motion to approve?
Motion to approve.
Any other questions or comments?
I guess I do have a question. Did we have a public hearing on this that where employees could come in and
We had
complain?
a committee meeting on it like about 2 weeks ago? Was it 2, 3? Yeah.
You know, I like the committee operation, except that a lot of that information doesn't come to us, those of us that are still have other jobs or have jobs that can't make all the... I'm really curious, do we have any people from the public come and complain or talk about it? Any of the employees?
There were public people there. There were some there.
Okay, but any employees who talked about this? Is 8%? What is that? 8.5% for us and them? Increasing the. Let's see.
I can't recall any employees.
My computer's gone down again, so I can't see what the documentation. Resolution increasing the county employees' medical insurance premium by 8.1. Is that the employee is paying 8.1 more, 1% more? And so what does that usually translate into dollars? You know, $8 a month or something.
Do you have that sheet with you?
I do have it with me.
I'm sorry to hold you up on this. And of course, the $64 question: does this include retired employees? Does this include retired employees? Seriously. And you don't need to, you know, drill down into everybody, but just some general idea about, you know, what a, well, you got some stuff to hand out. Oh, cool. Thank you.
In 2014, your increase was a 9.4%, so you're doing better than you did in 2014. This year, it's an 8.1%. If you look at column 1 on the sheet, Commissioners, you'll see, for example, the $300 plan. We set the employee premium at $759.63. That includes the 8% increase. That single person is paying $53.17 monthly, and the county is picking up $706.45 monthly.
Okay.
So I think on that particular union, it's a 93% county, 7% employee.
Okay.
So even though it's an 8% increase to that number you see, the 759, that's shared, you know, 93% and
Okay, this
7%.
helps. Thank you. This answers my question.
You're welcome.
Thanks a lot. I would like to show this to the employees sometime. You know, where...
We usually post, if I'm correct, we usually post it on the intranet once it's been out there. And so...
It's also public. Anybody that
Right.
goes to the Douglas County
Yeah.
website can pull what the employees' premiums are.
I'm really saying that because it's such a huge benefit when you're paying $53.17 a month, and the county taxpayers are paying $706.45. I mean, that's a huge, huge benefit. So it ought to be every employee should be aware of what's going on because it's part of the deal.
That actually
Thanks.
is a good point, Commissioner Boyle, and I think we could probably put together some pieces of the PowerPoint to actually have our CAO work with the department directors and elected officials to get that information for sure.
I think it ought to be
besides
stuffed.
putting
I
it
think it
on
ought to be
the
stuffed in
intranet.
with a paycheck
Yeah.
or something. But
We'll work on that.
could I ask one last question? I can't see this. Is this bottom area here, is that retired? The bottom line or not?
It is. There are two classes because they were changed and then they went back with the courts. So that one is N1 retirees and the other one are just retirees.
So, okay.
They're all
Retirees they're included in this. They're getting an increase as well?
Absolutely.
Okay. Okay. Thanks.
With that, did we vote?
No.
No. Okay, please vote.
Motion passes.
We do have need for an executive session for litigation. Is there a motion?
So move.
Second. Please vote. And I'm going in fast because I have to use the restroom. I said, I'm going fast. I got to use.
No, but it passed anyhow, so motion passes.
I'm short. There you go. Motion passes.
Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed his grace on thee, and crown thy good with brotherhood, from sea to shining sea.